Thank you all for joining us for our latest small group drafting meeting of the Justice and Municipal Court Appeal Project. I hope everyone had a good August and September and enjoyed the summer, which looks like ended yesterday. So we're going to dive back in to our review of our draft bill. But before we do that, we're going to have a little update about the Oregon Law Commission in general. We had a meeting just a few weeks ago, Sandy, 2 or 3 weeks ago. And for our purposes, what Krista and I reported to that group is that the status of our project, which is that we're going through this draft. We'll continue to go through the draft until we've got something that our small group is ready to present to our larger working group about justice and municipal appeals. And we also are going to be doing an outreach. Once we have the draft at a stage where we're ready, we're going to be doing outreach. So reaching out to the local courts, the justice and municipal courts throughout the state. And that's just going to take more time than we have to get a bill ready for the January 2023 session. So we let the commission know that that was our status. So we're going to keep plugging away, but the commission never wants to kind of have a bill that doesn't have all of the stakeholders' input considered before we take it to the legislature. We want things to go as smoothly and as professionally as possible in the legislature. And we know that we need to spend more time talking to folks once we have our draft in order. So we're going to keep going, but we are not going to do any mad rush to get something done for the January 2023 session. So that's my bit of the update. Sandy's going to give us a little bit of update about changes at the commission. Sandy?
Yeah, thank you, Justice Duncan. I appreciate it. So as I reported to the commission, the big change is that I will be leaving the commission, but for positive reasons. I have started a new role at the University of Oregon. It's a new position where it's the Senate Secretary and Advisor to the President. So I'm working with the University Senate to coordinate their entire program and increase the institution of the Senate and all pieces there. And I'm also working with the President's office in various capacities. So it was an exciting opportunity for me, but that will require me to find a replacement. We're working on that. UO, as a large public institution, hiring takes a while. So the university has been gracious enough to allow me to stay on with the existing projects and cover all those projects as part of my job at the university until we find a replacement. So, and that is open-ended, which I'm really grateful for them. So I will be here to support this and other projects of the commission up through when we find someone. We're looking to start a search as soon as possible. If any of you know anyone who might be good candidates, let me know, because it's a particular position, and it is one that I think has its benefits, but I do think it will be fairly difficult potentially to find someone, but we're going to work really hard at it. But with that said, we're going to be going through a transition. We're going to find a new director. In the interim, I'm still with everyone here. I just want to make sure that you know that for support, but I just want to provide that update.
Thanks, Sandy, and thank you for everything you've done to support our work group and the commission in general. We really appreciate it, especially as the commission was transitioning from Willamette to University of Oregon. You helped our chairs shepherd that movement for the whole commission, and so we're grateful for that and for all that you do for our work group. And thanks for continuing on, and you'll just let us know. You'll keep us updated about how the transition is going and how the replacement is going. And if anyone does know anyone who might be a good candidate, do reach out to Sandy, get more information about that position. It's really valuable to have someone in that role, excited about doing the work of the commission in that capacity.
And the one thing is it will continue to be a full-time position under the University of Oregon umbrella. So it comes with full University of Oregon benefits and everything like that. So in that way, it's quite an attractive position. So thank you.
So today we'll turn to reviewing our draft. We've got a few questions we want to go over. And then we're going to start off with continuing our discussion about the notices of appeal. And last time we met, we got to the point where we were talking about service of the notice of appeal. And that, if you have the handout, which is called, I think, the OLC procedural issues, we're going to be talking about the question at the top of page 8 of that document first, which is who should a notice of appeal be served on in all categories of cases, so civil, criminal, and violation. And we have set out in that document current sections 10, 11, and 20, which concern the service of the notice of appeal. So why don't we just take a look at that? Section 10 requires the notice of appeal with the justice to be filed with the justice court, served on the adverse party, and a copy served on the circuit court. And then there's the provision, which is in section 11, which is very helpful. And Jim, maybe you know how important this is. Because it can be confusing about which court you're supposed to file your notice of appeal when you're coming out of justice or municipal court. We have section 11, which says if you file in the wrong court, that's not jurisdictional. That's something that can be corrected. So the question, one of the questions that we need to address, and that has come up a little bit before, is who gets served with this notice of appeal? And John Henry has pointed out before that in justice courts, there's many cases where the case might be litigated in a violation case. The prosecutor might be the police officer, that might be the state representative. So what are people's thoughts about who needs to be served with the notice of appeal coming out of justice court? Obviously, I think we can leave the circuit court, we'll need that. But as far as adverse party, are we fine just saying adverse party? Do we need to be specific, more specific than that? What do people think?
I think on behalf of the litigant filing the appeal, more clarity would be helpful. And I would suggest that it should be served upon the district attorney's office, even though they may not be involved in the violation appeal. But that's going to at least ensure that the process moves forward, even if they can't represent the state. They'll make sure that the officer is summoned in all likelihood, and will at least move the process along. So it's really more to help, quite frankly, the appellant that I suggest that. Mm-hmm. I don't know, John Henry, what you think about that. That's just my off the cuff. Well, you're on mute, sir.
If I was a deputy district attorney and something like a copy of a notice of appeal like that came across my desk, I'd say, well, this might be a nice thing to start the fire with tonight when I get home. If it's a police officer who's prosecuted the case, it seems to me that there's some language that could be inserted to just say, if a police officer or peace officer, whatever the term is going to be, and there are many different names for those executive officials, maybe it'd be a good idea to put that in, because I think the vast majority of traffic violations are prosecuted by police officers themselves and not by prosecutors.
Oh, that's I agree with you entirely. That's certainly the case in my court. I mean, it's not even remotely close. Less than 10% of traffic violators have attorneys. The other thing is that would be there. I should say that that's really in conjunction with the fact that you're serving the circuit court. There's the appeals staff person in the circuit court that would be obviously served as well with the filing, and they actually will then initiate and send out court dates. At least in this county, that's what would happen.
So how does it work?
We send that to them because the appeal is actually filed here at the justice court, and then we send it over to the circuit court. So we're sending it to the correct circuit court staff person.
So who does the circuit court notify then, Judge Cross? So if you have a police officer appearing and the circuit court gets the notice from your court and sets the date, who does the circuit court contact? Do they contact the police officer? The police officer says,
I know they send out paperwork to the appellant. I don't know. I can't sit here and tell you that I know that they send out the court notice to the police officer, although I would certainly expect that to be the case. I just don't know, and I didn't think about that, or I would have called and found out.
what do people think? I mean, we're right now talking about the justice courts, but they can have county or state offenses, right? So is it possible that the respondent on the appeal would be represented by the district attorney or somebody out of county counsel's office? Who are the possible representatives of the respondent in these cases?
It's potentially county counsel if it's a non-traffic violation, if it was some type of code violation, a noise violation perhaps, or something out of, like a parking ticket out of Hag Lake, or was issued by a county, or certain other things which would come up, like if it was if the animal control violation. That's not part of the standard JP duties, but in this county, the justice of the peace has traditionally been the animal control hearings officer. And when I took over at the behest of Judge Chartel, who I replaced, and I continued that. Although the only thing that really made me cry was the one day I had to order a dog be put down. And I came back into chambers and I shed a few tears. I had no choice because of what the dog had done, but it was heartbreaking. But anyway, that would be a county counsel.
So it's going to vary. So we can't say across the board, perhaps serve the district attorney or serve county counsel, but could we say if the defendant in the lower court case is appealing a conviction for violating a county ordinance, then the notice must be served on county counsel, or 2, a state ordinance or state statute, then the notice must be served on the district attorney's office.
Right.
Would that
And
work?
I think that it would work. I think that would work, Justice. And I think that I think it should be incumbent upon the justice court or the municipal court, for that matter, when we get to that point, but it should be incumbent upon us to tell the defendant that, so that they know what they have to do, because I don't think it's fair to try and make them figure that out. So I think in the paperwork that we give them, because again, they file it here, we give them the packet, and they fill out and return to us. And I think the packet needs to contain that information.
Okay.
For them.
Okay.
And I think it should be incumbent upon the court from which the appeal is being taken to do that.
So to help them even figure out whether they have been found in violation of county or state law. Okay.
Yeah. And we should have different forms depending upon who the appropriate office would be to have them serve. One for if it's the district attorney's office, one if it's the county county. They're very similar forms. We have to make sure here that we give them the right packet.
Or even maybe the form is like, I've been convicted of this, which is a check 1 county or state violation, and then depending on which one,
absolutely,
it might instruct where to serve. Okay.
Yeah, I just think, and again, I know my staff will say, why would we have to? I know it. Actually, they won't do that. I think they're very understanding that of the duty that we have, and I think that's a duty we need to fulfill.
Is it always clear from the charging instrument the offense, whether the offense is a violation of state law or a violation of a county ordinance?
I wouldn't say that it always is. I would say that it usually is.
Because that's what as we were talking, I remember looking when I worked for the courts at some of the charging instruments, and it wasn't always clear to me what the person, I mean, there would be a name of a charge, but it wouldn't always be clear whether that was a state violation, because you can have state violations too, and then you can have county violations, and it wasn't always clear to me which one it was.
And it should be clear to the left of the actual verbal description of the violation, there should be a number. And it should be clear whether that number is an ORS or whether it's a county code violation. But I'm not going to kid you, it's not always clear. Most of the time it's clear, but also then you're relying upon the defendant to understand the difference between those two things. I look at it in a heartbeat, I can tell that. The defendant can't necessarily understand that and tell that. So it's incumbent upon, I think, this court, when the appeal is being taken from this court, to make sure the defendant knows that and knows which, what their next step would be. And I think we need to perhaps statutorily define and say that that's the obligation of the court.
Do you ever have situations where a defendant is charged with multiple counts, one of which would be a violation of a county ordinance, and another would be a state charge?
That is certainly theoretically possible. I can't think of that happening off the top of my head, which doesn't mean it hasn't. Certainly there was never an appeal that came up in that circumstance, because that would have certainly been drawn some attention. But I can't think off the top of my head of that occurring. Anybody else ever have that happen?
The thought occurs to me that maybe one solution, I think it would be helpful if the trial court, the justice court, was charged with informing the defendant whether it was a state or county offense. But I'm wondering whether another possible solution would be to make it to make timely service non-jurisdictional, so long as the defendant served one or the other. It could then be fixed later, but so long as the defendant either served county counsel or the DA timely, the circuit court could then instruct the person, your service is deficient because you failed to serve the correct respondent, and the person could then fix it. And that's kind of the same solution I wrote into with respect to the filing requirement, because whenever, in my experience, even though the statute may be clear that you're supposed to either file the original with the justice court and serve a copy in the circuit court, or vice versa, people don't always appreciate the difference. And I think we should make it non-jurisdictional. So long as you served one or the other, we can always fix it later.
I will say
That's a really good idea.
We do have a form here we give folks which tells them that, and nobody leaves my court. If they've lost a trial in my court, nobody leaves that court without me verbally explaining to them what their appeal rights are and what the steps are. But that's in the wake of the aftermath of a trial, and then this judge is like verbally saying a bunch of this stuff to you. I'm not going to sit there and tell you that I believe that the retention rate on that is good, but hopefully that, in conjunction then with the form, is sufficient for the traffic violations and for county code violations. Small claims are different because the 10-day timeline is ridiculous, in my opinion. I know that's a different issue, and I think we're going to get to that, but I mean, it's because that's number one, the filing process is more complicated for the appealing party, and then they have such a short time frame. It's just not reasonable in my opinion.
Can I just note, on the subject of the the service requirements. Currently, section 11 is different from section 20 in the jurisdictional nature of it, I think. So section 20 already in subsection 2 already explicitly said that timely service is not jurisdictional and the court may extend the time, whereas subsection 11 doesn't have that.
Okay.
Exactly. So if we want to make those the same.
And the reason for that is that under current law, on appeal from justice courts and municipal courts of record, under ORS Chapter 19, it makes service on the either the state or the county, and makes timely service non-jurisdictional, and something that can be fixed. There's no similar provision under current law in civil cases, typically because in civil cases, you know who you're dealing with. You know who the adverse party is. If that person has a lawyer, you've been dealing with that lawyer. If the person doesn't, you know who it is. In justice and municipal courts, if you've got a police officer, you don't know always who you're supposed to serve. And so that's why under current law, timely service on the city, on the state or the county or the city is not jurisdictional and something that can be fixed, but the same rule is not applicable to civil cases. We may choose to change that, but that is the status of the current law.
And a quick question on section 20, sub 1, sub B, sub large A. When it talks about serving the district attorney for the county on appeal from a proceeding involving a violation of misdemeanor defined by state law, should that say violation or?
Yes, I think it should be or. Was a
Okay. Yeah.
typo on my part.
I was guessing that was the case, but I thought it's a rather important. Sometimes 2-letter words are the most important thing.
Yes.
Or 1-letter words. I once had an hour-long debate with Justice Mick Gillette at a bar function dinner over what the word "a" meant in a certain opinion. The rest of the table was not enthralled with this, but he and I were just enraptured with it.
While we're still on the topic of the notice of appeal, I was curious in terms of what this group's intent was with serving the circuit court with the notice of appeal, because my understanding is that typically the notice of appeal will go to the trial court level, and then the file would be transmitted to the circuit court, which would initiate the actual new case filing in circuit court. And so I just wanted to clarify what the intent of the service of the notice of appeal, if this group was contemplating it triggering the actual creation or establishment of a new case in circuit court, and kind of shifting that process a little bit.
I can tell you what my motivation it was, and that's that. And it has to do with who has jurisdiction to do what. In civil cases, there's litigation that can go on in the justice court over the undertaking. But in violation and misdemeanor cases, there's nothing else for the trial court to do but forward the record to the circuit court. Meanwhile, in my view, as soon as the notice of appeal is filed, the circuit court has jurisdiction of the case and the justice court does not. The justice court only has, I shouldn't say they don't have any jurisdiction at all. In civil cases, they have jurisdiction to deal with undertakings, but the justice court can't change the judgment. The judgment is whatever the judgment is. And for instance, let's say that there was a defect in service and there was a motion to dismiss filed. Should that motion be filed in the justice court and ruled on by the justice of the peace, or should that motion be filed in the circuit court and ruled on by the circuit court judge? If it's the latter, you could have a situation where the notice of appeal was filed in justice court, and the circuit court gets a motion to dismiss relative to a case it knows nothing about. And that's why I was thinking that the circuit court should get notice that an appeal has been filed, so that if there is any litigation, the circuit court knows what that matter, what that litigation relates to. And it also would follow the model of appeals from circuit court to the appellate courts.
That was really helpful. Thank you so much. And given that rationale, which is essentially to more clearly establish who has the jurisdiction over the case at that point, it sounds like the intent is to trigger that, trigger the establishment of a new case in circuit court, kind of, just so then the circuit court, should there be any issues or needing to deal with anything, because currently right now, as noted, the circuit court typically waits until it receives the file, any filing fees that need to be addressed as well, if applicable, and then that is kind of the triggering factor for establishing a new case file. So this is helpful. Thank you.
Now, one other thing which is frequently confusing to litigants is the fact that, well, they file the appeal like in the justice court. It goes, we send it over to the circuit court. But if they need to seek a waiver or reduction of the filing fees before they file the appeal, they have to go to the circuit court to get that kind of a relief, and then come back to the justice court with the order from the circuit court, and then file at their reduced or waived rate. It is difficult for litigants to, even when you explain it to litigants, it's difficult for them to go through those steps and understand those differences that they have to in the two different venues they have to go to. I'm not saying I have a solution for it, but
it is tricky. And I mean, I know that why for these appeals, we allow the appellant to just file in their current court, which is not normal, because normally you would file in the court to which you're taking the appeal. But for ease of the appellants, we have left the notice of appeal with the justice or municipal court, but that does lead to the problem in the cases where a waiver is required, like you're saying, Judge Cross. I don't know if on balance, it's better to leave it in the justice court, perhaps. But if they need the waiver before they can, well, here, I guess the question would be then, are you in your justice court accepting the filing fees for these?
we receive the filing fee. So again, I make it very clear when they do that, if they're doing, a cashier's check or a money order, they must make sure that it's made out to the state of Oregon, not to the justice court. But yes, we receive that, and then we send that over with the appeal paperwork to the circuit court. If the funds are not included, the circuit court will not accept it.
Is there any, so there's this possibility of ping-ponging someone who can't afford to pay the filing fee.
Right.
Should we think about whether, I don't know if this is even possible because the fee is not the justice court's fee, but what if the justice court were given some authority to waive the fee? Is that possible? It's not their fee.
Right. That's the problem. I mean, I would love to have that authority, but I think it's I don't know if it's really. I think the circuit court might not think that was such a good idea.
That would be that would be an argument, in my view, in favor of switching the requirement so that the general rule would be that the original notice of appeal would be filed in the circuit court, and the person would then pay the circuit court filing fee to the circuit court. and have a copy of the notice of appeal served on the justice court. Then the circuit court would have jurisdiction as of that moment to rule on whatever matters came before the circuit court, and the justice court would retain the authority it has under current law to deal with matters having to do with the undertaking.
And I think legally that makes perfect sense. I just think that it's not necessarily going to be helpful or beneficial to potential appealing litigants, because it's more difficult for them to go in, and quite frankly, I think oftentimes there's less help that they can receive from circuit court fees. I think we tend to be pretty helpful here to folks perfecting the process.
How confident are you that the procedures that you follow in your court are followed by the other justice and municipal courts?
I can't speak to that.
I can. I don't know any justice of the peace that is more helpful and protective to the people that go before you than you. And if you go east of the mountains and you have a non-lawyer justice of the peace and somebody starts talking about appeal, they're not going to get the same help that you give people. So, Jim, that's a great question. And I've seen stuff that could fill a fun book, keep you up at night.
So I think this is a significant issue for our group to think about which court we should start in, the notice start in. One argument for having it start in the circuit court is you don't ping pong, and the process is the same process that people are generally familiar with, which is that you file the notice in the court that you're going to be bringing the appeal in. The flip side of that are the additional requirement that the appellant find a new court and figure out how to navigate that new court. So I think that's something that we should keep thinking about. And that might be something where we have, I don't know, this group could draft the bill one way, but have an alternative. Think about how it would look the other way, or our group can come up with a proposal about which way we think is the best way, and then take it to the larger group. But it can be a kind of access to the court's way issue either way we go on this. Okay.
One final argument I would make, I'm somewhat persuaded by what has been said, and the phrase, if it ain't broke, don't fix it.
Mhm.
If the current process is working well, even though it might not be kind of ideologically pure about how we like things to go, if it's working, then leave it alone and continue to have the notice of appeal filed in the justice court, have the circuit court filing fee paid there. I still think I would like to have the circuit court receive a copy of the notice of appeal, just so that they know there's a case there.
I think that's
And the justice, we send that to them because we send the pleading, we send the filing there, and we that's our responsibility currently. And so you do that. But by the way, I yield entirely to John Henry with the experience of how consistent this is across different courts. Few folks have the breadth of knowledge of different jurisdictions that John Henry does, and I really I take that very seriously, and I'm convinced that perhaps I'm probably incorrect in saying that we should have the justice courts do all these things because of the perhaps lack of that the circuit courts would have greater consistency. So I don't like to say that, but perhaps that is the more appropriate answer.
Maybe I can ask one related question, which is, does anyone know what the filing fee is? And that might give us an indication of how frequently people are going to be bouncing between the two courts.
Currently, for a traffic violation in this county, and I think it's probably the same anywhere else, is $420.
Oh,
Yeah, which of course is greater than the fine most of the time.
yeah.
Which is a very, in fact, I've been here now almost 6 years, and I think there have been 3 appeals from traffic violation convictions from this school. I guarantee, and I don't like that. I mean, I like to think that I'm right all the time, of course, but the fact of the matter is that the cost, that is a chilling effect and impact on potential appeals.
Yeah.
And in small claims cases, I think it's 290, but I'd have to look at it like that again. So, and in small claims, I've probably had, well, and this again, maybe 1 a year.
I just looked it up. I just put in Lane County just for, it's 281 is what's listed on the website there, just as comparison.
For small claims
For an appeal,
or,
an appeal from a justice or municipal court specifically.
okay, okay. So it wouldn't seem like it would be infrequent for people to seek a waiver of that. Okay. Any other thoughts before we move on from that? Which
Just-
court issue? Yeah.
Oh, just briefly, I just wanted to comment that if there is a contemplated shift in terms of the procedure, and I tried to kind of foreshadow this a little bit of what the existing practice is, that one would probably, if there is a shift in terms of where the filing takes place or shifting the practice pretty significantly more in the circuit court direction, I would anticipate there'd be some business process changes that OJD would need to evaluate and contemplate. And so just keeping us in the loop, and if you would like us to provide more information or start looking into that and how that might look, please feel free to let me know.
I have a question. Should we just ignore typographical errors?
Oh, no, tell me about them.
Oh.
I can fix them.
You want me to say something?
Yes.
Oh, under section 11, subsection 4, it says 92, and what was meant was pren to pren. And then instead of is it is. Sorry,
And
nitpickers.
I'm sorry, you're looking on page 7, top of page
Oh,
7.
page 8.
Page 8. Jessica, I think those are my typographical errors.
Oh.
Like they're not in the bill. There's
Oh,
my retyping
okay.
of the bill. So I think we're, so.
I beg your.
Yeah,
sorry.
no, that's my
Indulgence, Your
92.
Honor.
I saw it today and I cringed. I was like, ah,
Okay, I
there's
was
some
looking at,
more. But yeah, those are probably not in the bill, but in the retyping of the bill.
could I ask a really, sorry, I didn't mean
ahead.
to interrupt, but I just want to ask a really quick question before we move on, which is, other than fixing the typo, which is in the bill in section 20, which I've already fixed, I'm not hearing consensus on any definitive step that we're taking based on where this is originating and where they're paying the filing fee. Is that right?
I haven't heard consensus.
Oh, I think you're muted, Justice Dunn.
There we go. No, I don't think we've settled on that. What is the sense of this group about whether this group should try and settle that today?
Well, I hadn't thought about the motion to waive the filing fee. It seemed to me that either the initial authority to rule on that motion would have to be with the Justice Court, even though it's not the Justice Court's fee, if we stick with the current system of having everything filed in the Justice Court in the first instance, and then having the paperwork forwarded to Circuit Court. If we change that and we want the Circuit Court to rule on the motion to waive fees, then I think we should seriously think about flipping it so that the original notice of appeal is filed in Circuit Court and the service copy is provided to the Justice Court.
one other thing, I know some folks have been saying, talking about the fees in different counties. In Washington County, when I say it's 420, there's a filing fee and a trial fee. And the circuit court requires the appellant to pay both of them combined in order for the filing to go forward. So that's where you make it some differentiation in some of these totals. That being said, I think Jim makes an excellent point, which is, if you're going to originate it in the justice court, then the justice court, in my opinion, should have that discretion. Or if one wants to throw one more wrinkle into the mix, perhaps what it could do is authorize the justice court to defer the filing fee, which will let the appeal then go forward. And ultimately, the circuit court can decide whether or not it should be waived.
That seems like a really good idea. We'd stick with our not perhaps, well, if we were to stay in the justice court, we would eliminate the ping ponging, by allowing the justice court to defer. The justice court wouldn't be precluding imposition of that fee if the circuit court thought the fee was necessary.
Right.
What do people think about that?
Yeah, I don't know if the justice court would need to even rule on it. It simply be a requirement that either you tender the circuit court filing fee or you file a motion to waive or defer the fee. In either case, the justice court simply forwards that along with the notice of appeal in the record to the circuit court, and the circuit court then rules on it.
Okay, right. So it may be, yes, no actual deferral, but you file it with a motion. That could work.
We would just have to then the change we make is that the collection of the fee would not be required to send the appeal on to the circuit court. That's fine with me.
They'd either have to submit the fee or you'd have a motion form that they could complete for a waiver.
Yep.
Heidi, any procedural concerns about that from perhaps the circuit court perspective?
It would be great maybe if we're kind of tinkering with it. If there's something in writing, then I can if this group has consensus on kind of policy concepts with regards to filing fees, that I can then take and preview with my team, that would be great. I don't want to kind of weigh in or make it seem like OJD is coming in with a position at this point in time, because again, these are some policy decisions that are going on. But I can, as with any type of process change, there might be some business process pieces that might need some tinkering and changing. So just want to preview that and be upfront about that.
Okay.
It just dawned on the circuit court already has the authority, I think, under the statute that governs filing fees to waive or defer circuit court filing fees. And I think that would be applicable to appeals from justice and municipal courts. So really the only thing we would be changing, I'm not sure that we're changing anything. It may be that litigants in these cases don't know that they can ask to waive or defer the circuit court filing fee, and that's why none are being filed.
Okay.
Again, I'll tell you, in my court, they are informed that they can that exists, but that they have to go to the circuit court to achieve that. So we tell them.
Okay.
Here.
So
I can't speak for other courts.
So perhaps the change we would make is to put it in statute, put it in the statute that the motion would be filed in the justice court, and then the justice court would be responsible for forwarding it on to the circuit court if we choose to do that.
If the filing is going to remain in the justice court, because if we send the filing over to the circuit court, then of course you're absolutely right. They have their whole process there with seeking a deferment or a waiver.
I think the statute gives the justice court, actually, I don't know if it does under current law. Does it just say that the justice court shall forward the record, or does it impose a time limit or say promptly?
I think there's some language about promptly. I don't think that there's a time limit, but it's been a long time since I looked at it.
Yeah, the thing that would, and I think what I put into the bill, what I put into the draft bill is like that the record must be forwarded over within 30 days, just so that it would have a standard.
Right.
Okay. So on the which court question, does this group want to, what direction should we give to Jim and Jessica about which way to at least propose to go forward with the which court question? Should we have two proposals? Should we stick with the current process, but then have an option for filing in the circuit court? Or should we, with this group, what are thoughts? Krista, do you think this is something that we should pick a path and then we'll take it to our larger group and identify this as a policy question, see what they think? What do you?
I wonder if it would be most helpful to just take the question to the larger group, because we have a very limited slice of the pie here of experiences.
Okay, I think that's true. All right, then I'm just gonna ask one last question that we might be able to resolve with respect to who gets served. In section 20, it talks about the private prosecutor. Can anyone speak to who that might be and what instructions or how the appellant would serve that person? When does that come up?
There is a provision, for example, that a average citizen could issue a traffic ticket, for example, to a driver. They have to. I've only seen it once in my time here, and it's really weird because they fill it out, but then they have to get a law enforcement officer to serve the citation upon the accused. And but then the responsibility to prosecute the case is with that private citizen who initiated the filing.
Okay. And do we have any idea or experience with appeals in cases where the complaint? No. Okay. Maybe we just leave it that there's service on the private prosecutor, which if it comes up, people will figure out how to serve that person.
Unless that also refers to if some counties, maybe they don't have a county council officer or DA's office, maybe they contract with a member of the bar to prosecute. John Henry, are you aware of that in any jurisdiction?
Unfortunately, I'm so old, I seem to recall that a private prosecutor could bring an action in one of these lower courts on their own. And not just traffic cases, but I'd have to really think hard and long about that. And I think that that's such an outlier issue that anybody that wants to delve into that ought to pay a lawyer that has a lot of knowledge or time to do interesting research for a whole lot of money.
Yeah. And
just not talk about it anymore.
Okay. I think it is so rare, we don't need to worry much about that. Let's go to the question about whether our work in creating the revised statute we should provide any additional information about how appellants need to serve people. Judge Gill said, if we don't think mailing or personal service is sufficient, perhaps we could include a distilled version of ORCP 7D, 7, that's letter D. Or do we just trust that as in other instances, people will find their way to the civil procedure rules about service and figure that out?
The only thing I would say is to reiterate, if it ain't broke, don't fix it. I haven't heard of all the issues I've heard about appeals from justice and municipal courts. I haven't heard anyone talk about flaws in how service happens.
Okay.
The only case I am aware of that I hope this legislation fixes was a Court of Appeals case where a lady filed the original notice of appeal in circuit court and served the justice court with a copy of it. And the Court of Appeals ruled that that was a jurisdictional defect because you're supposed to serve the original in the justice court. I would hope we would fix that, but that doesn't change the process. Process should be this under current law could stay the same because I'm not aware of any issues.
Okay. Is anybody else aware of any issues that might merit our adding something to the statutory language? Okay.
I do have a couple of drafting questions, perhaps for Jessica. In section 11, subsection 1, oh, no, excuse me, section 10, 2A, says serve a copy of notice of appeal on the adverse party or the attorney for the adverse party. Read literally, if a party is represented by counsel, you could choose either one, when it should be you serve the attorney if the party is represented by counsel, and if not, then serve the defendant or the adverse party.
I made some of those changes in section 9 based on our last meeting, so I could just make those same changes to section 10. And I just used the language from, sorry, what was it? ORS 19-240 when I'm talking about the mailing address. So obviously I wouldn't include mailing address, but I can use similar language here.
And then the second one was in section 11, subsection 1, referring to the circuit court has jurisdiction to exercise judicial authority. At least it should be upon the service of the copy of notice of appeal, not on the filing, because the original would be filed in justice court and only a copy served on the circuit court. And then in section 21A is that same issue about serving the attorney or the defendant. So I assume you'll modify that wording also.
Jim, can I take you back to section 11.1 where you were talking about when the jurisdiction switches and you were going to change filing to service? If do we want the jurisdictional change to occur when the circuit court gets their copy, or only when the notice is filed in the justice court? Because it is possible that the circuit court could get a service copy and would, right? Because you have to serve before you file. So the circuit court could get a service copy before the notice is actually filed in the justice court. And then the question is, which of those events should trigger the jurisdictional change?
Perhaps it will be the circuit court's jurisdiction upon the perfection of the filing of the notice of appeal.
Yeah, the trouble, there's been some issues over what the word perfection means.
Do you want them to just comply with the section 10 requirements?
So it's nitpicking lawyers like John Henry that cause these kind of questions.
Yeah. And there's also the question of the timeliness too. Because one might properly file the original notice of appeal with the justice court, but do so outside the time limit. And I guess the question comes down to who at least initially rules on those issues. Do you want the justice court to rule on those subject to review by the circuit court? Or do you want the circuit court to be ruling on those in the first instance?
Seems like it would be a circuit court function if it's an appeal.
I would tend to agree, yeah.
Yeah. Well, I certainly think that militates in favor of requiring the party to serve a copy of the notice of appeal on the circuit court. It doesn't necessarily have to be jurisdictional to do it timely, just so long as that it gets done and the adverse party is not prejudiced by it. And then that would give the circuit court the authority to rule on any motions that get filed that have nothing to do with the merits of the case at all. It's just, whether you've satisfied all the procedural requirements.
John Henry.
In 1968, at the University of Texas Law School, my professor for civil procedure, George Shotsky, told the class, a court always has jurisdiction to determine its own jurisdiction.
Right, and that's kind of what I was trying to say in subsection 11 sub 1. Not only does the appellate court have the authority to determine its own jurisdiction, but it also necessarily has the authority to issue an order saying, you forgot to pay us the filing fee, send the filing fee, or we're going to dismiss your case, or you didn't do something else that the statute requires you to do, either fix it or we dismiss your case. So the circuit court always has to have the authority to do what might be considered administrative type tasks, but they are cloaked with the judicial authority of the appellate court. And I distinguish between that authority and the authority to decide the appeal on its merits, which should happen only after the appeal is quote unquote perfected, whatever that means.
So where does that leave us with section 11.1, filing or service? It seems like the filing is what starts the appeal. Even if you've already served a party or another court, it seems like the case isn't live until the notice is actually filed. So
I think intellectually that makes sense, but if we retain the requirement that the filing of the original notice of appeal happens in justice court, you have a weird situation where the original notice of appeal is filed in the justice court and somehow magically the circuit court has acquired jurisdiction to rule on a case it knows nothing about.
Yeah. Okay. So filing or service, or is that not settled?
I tell you, just for the sake of discussion, I'm going to make a motion that the proposed bill require filing of the notice of appeal in circuit court and service of a copy in justice court, but that it, as it is currently written, that a reversal of those things would not be a jurisdictional defect, so long as the initial filing was timely. Well, if you file your notice of appeal within 30 days, if you file it in the circuit court, and you serve the justice court, or you file the original justice court and serve the circuit court, it doesn't matter, you're good to go. But that the default would be you file the original in circuit
in the
court.
circuit court. So we are, so we have a motion from Jim on that. We are also at 2 o'clock, which is the end of our meeting time. Can we let's carry that motion over to our next meeting. I think this is a significant policy question, and that we'll need to provide some guidance to Jim, to the group, as we decide, are we going to propose switching the court of initial filing?
Mhm.
Either way, whichever one, but I think, Jim, that whichever one we go with, you have language that we would include, which is what you said, which is if you get your court wrong, as long as you got it to one of those 2 courts within the 30 days, you're fine.
Yeah.
Okay, so let's carry that motion. It's 2 o'clock, 2 minutes after 2. That leaves us with next time we meet, which Sandy set up the following meetings.
Yeah, we have meetings scheduled November 10th and December 9th. Keeping the reason November 10th is a Thursday, we were going to do, that was because of a holiday
Right.
the next day, and then December 9th is the third meeting we have currently scheduled.
Okay. So we will pick up where we are leaving off now, which will include Jim's motion, and then we'll go on to small claims provisions at our next meeting, and the rest of the agenda items then.
So
Yes,
what I'm
go
planning
ahead.
on, what I'm planning on doing is the only consensus for changes are a couple of typos that I found and that were pointed out to me. And then modifying that language in section 10, subsection 2A. So we're saying adverse party, or if the adverse party is represented by the attorney, making that same change in section 20, subsection 1A. And those are the only changes based on today's meeting that I'm hearing. Okay. So what I will
Well,
do.
there is one other one that says the violation of, and it should say
Right.
violation or.
I've made that change. Yeah,
Okay.
sorry, that was included in the typo.
Okay.
So what I will do is I will send out a second version of the work draft, which will include the consensus changes from last meeting and today, and I'll send it out just for a quick review, and then possibly that would get circulated to the larger group. Okay.
Yeah, that
Sounds
sounds
good.
good.
Okay,
All
thanks.
right. Thank you for doing that, Jessica. All right. Thank you, everyone. We will
Thanks, everyone.
see you at our next meeting on the 9th.
We'll see you in a few weeks. Thanks, everyone.
Thank you.